Before we even hear the first word from the judge, let's pause, because this case is already loaded. What looks like a simple eviction spirals into a three-way credibility battle between a landlord, two tenants, and a maintenance man caught in the middle. On one side, a property owner claiming unpaid rent, ignored deadlines, and a lawful eviction process. On the other, tenants alleging unsafe living conditions, city code violations, and what they describe as a self-help eviction. And right in the center, a judge trying to untangle timelines, texts, partial payments, and legal obligations under Texas eviction law. This case isn't about who's louder, it's about who can prove what and when. Did the tenants legally default on rent? Did the landlord properly serve notice? Were the conditions truly uninhabitable, and if so, did the tenants follow the correct legal steps before withholding rent or moving out? These details matter, because eviction court moves fast and emotion doesn't override procedure. As you watch, pay close attention to dates, amounts, and who communicated with whom. Because by the end of this hearing, one small misstep could decide everything. And trust me, there are several moments in this case that will make you stop and say, wait, that changes things.
Mr. Great, you filed this case in my court on or around November the 19th. In your petition, which is also known as a sworn complaint, you swore to me that the defendants defaulted in the terms of their lease by not paying rent for the month of November, and that they owed you $1,204 in back rent. You also indicated that they held over past the renewal term or extension period, which was the 18th of November. So I'll get a little more into that as well. And the other thing that you swore to me is that you hand delivered the notice to vacate to the defendants on the.
This is an important moment because the judge just laid out something viewers often miss: who carries the burden of proof and in what order. The landlord goes first, not because the court favors landlords, but because they filed the case. That means the landlord must prove two things clearly and convincingly. First, that rent was not paid as required, and second, that proper notice to vacate was given under the law. Only after that happens do the tenants get their turn, and their burden is different. They must show either that rent was paid or that the landlord failed to follow the law. Claims about habitability, maintenance issues, or unfair treatment don't automatically stop an eviction unless they're paired with proper legal steps, like written notice, repair requests, or escrow actions where required. So here's the question for you watching. If you believe your landlord is wrong, would you know the exact legal process to protect yourself? Or would you assume fairness alone is enough? Because eviction court doesn't run on assumptions, it runs on proof.
On the 15th of November. And so this is going to be your case. You're going to have to provide proof to me that one, the defendants defaulted in terms of their lease by not paying rent and that they owe you the rent for November, and two, that you did give them proper notice to vacate. So you're going to speak first, Mr. Great. And then while you're speaking, I'm going to ask that you, the defendants, Ms. Henderson and Mr. McGinn, don't interrupt her. Okay? I want to make sure everything that she's saying. All right?
Yes, sir.
Okay. And now, once you, Mr. Great, are through, again, you'll be able to bring Mr. Lacey in because he's your maintenance man. He'll be able to provide testimony as well. Once y'all are through presenting the case against the defendants, I'm going to consider y'all to be at rest. Then I'm going to give you, the defendants, Ms. Henderson and Mr. McGinn, the opportunity to defend yourselves. It's going to be up to you to provide proof to me that you did not default in the terms of your lease by paying your rent, and that the plaintiff did not follow the law in regards to having this case filed. And while you're speaking, I'm going to ask that you, Mr. Great, do not interrupt them. I want to make sure everything that they are saying. Okay?
Okay.
All right. Any questions before we get started?
Yes, sir. I actually do have a question.
Okay. I will try my best to entertain your question before we get started. Go ahead.
So we were served on November the 24th. I know typically we would have 14 days to do our answer. That would be on December the 8th. Was there any specific reason why we wasn't allotted that 14 days with due process?
So, you said you were served on what day?
On November the 24th?
With the eviction paperwork?
Yes, sir.
All right. And so this is what the law says in regards to evictions. With evictions,
This exchange right here is a textbook example of why eviction law feels confusing to tenants and why judges spend so much time explaining it. The tenant raises a due process concern, believing they were entitled to a full 14 days after being served. But the judge clarifies something critical. The clock starts when the case is filed, not when you're served. In Texas eviction proceedings, the hearing must be scheduled no sooner than 10 days and no later than 21 days from the filing date. Service delays don't reset that clock. That means someone can feel rushed, even though the court is technically following the law to the letter. This moment matters because it removes one potential defense entirely. The court isn't deciding whether the system feels fair, it's deciding whether the system was followed. And right now, the judge is signaling very clearly, procedure was met. So let me ask you, should eviction timelines be longer given how much is at stake? Or is speed necessary to protect property rights? Drop your thoughts in the comments.
a case cannot be scheduled earlier than 10 days and not later than 21 days.
Okay, so then the 10th day would technically be the 6th, correct? Or the 4th?
This case was filed. Well, not when you were served, whenever it was filed. This case was filed on November 19th. The constables at that time received your paperwork on or around the 19th or the 20th of November. At that time, they have so many days to serve you. So it's not when you're served, it's when the case is filed. So again, you were served, as you stated, on the 24th, but the case was filed on the 19th. Okay, any other questions, ma'am?
That's it.
All right. So I do have a couple of questions. This is to you, Mr. DeGray. Do you any agreement to Waco Housing Authority to subsidize the tenant's rent?
Say that again.
Do you have any agreements or contracts with Waco Housing Authority where they pay so much of the tenant's rent on their behalf?
No.
Okay, all right. So tell me this, Mr. Gray. You filed several documents with me, and one of those documents was a monthly rental agreement.
Yes.
Tell me a little bit more about that.
Okay, so I never put anybody on a 6 month or 1 year lease because I want them to be able to leave anytime they want to leave. And if they're not paying their rent, I want to be able to let them go. I don't want to have them tied up. So that's why I do a month lease. Not saying that they gotta get out. They just on a month lease. Because when you lock somebody in for a year and then you have to evict them, now I'm breaking the lease. So I let them know up front I do a month lease so they can leave whenever they want. And if they're not paying their rent, then I don't have to worry about they've been in a lease for me 6 months or a year.
Okay. And so the terms of this lease that you have with the tenants, based on what I have in front of me, y'all agreed for them to pay you $1,175 per month. Is that right?
Yes,
Okay.
that's their
And
monthly rent.
the rental agreement, I'm looking here, it started in October. Is that right?
Yes, I preferred them to move in on the beginning of the month of November. But however, they were saying that they needed to get a place right away. So I let them move in at the end of the month of November, and from the 23rd or 24th, and then she paid $300 for the month of October. She paid the deposit of $1,175, and she paid $555 towards November's rent, and was gonna give the remaining balance on the 1st. I had told her that, well, why don't you just wait till November 1st to pay? And she stated to me, no, I like to pay upfront, half and half, because I have to do my bills like that, because if not, I won't be able to pay my rent. And it's just better and easier for me that way. So I said, okay. So she paid $555 for the month of November. At that time, I told her, I do not call you. I do not hound you. Here's the agreement. Your rent is due on the 1st. It's late on the 5th. You have a late fee. The next time that I will call you is when I will be evicting you. So at that time, when the 5th came, she did not call. Her nor Jonathan called me to say that they were going to be late. The 6th came, then I charged her a late fee. After the 6th, I waited and waited. During that time, the maintenance guy had came to me and said, because they know each other, and that's how she was able to he referred her to me to move into the house. So he came to me and said that she wanted to pay her rent late, and that if I could be easy on the late fees. And I responded to Brandon, I do not rent to you, I rent to them. They need to talk to me about their rent. They need to call me. So he went and relayed the message to them, but they never called. So I waited and waited and waited. And then on the 9th, I sent them an eviction letter through text message of corresponding, and was about to mail them a eviction letter on the 9th. At that time, they contacted me around by 5:48 or 6:48. I can't remember what time. Jonathan contacted me from Miss Antoinette's phone, and he was saying that we were going to pay you this and that, but there is no communication. And I said, I've told y'all at the beginning, I don't hound people for their rent. I don't do that. You know when it's due and when it's late. You have the contract. We both have a copy. I said, but you did talk to Mr. Brandon Lacey, and Antoinette said that she told you to call me about the rent. You told Mr. Brandon Lacey that you was not going to call me, that is Antoinette's job. So no one has contacted me about the rent. So I've been waiting. Now, today that I send you an eviction letter, now you want to contact me. So at that time, I told him and her, do not talk to Brandon about their rent. Talk to me. They only talk to Brandon about maintenance things. So they requested to, well, we got your money. We're going to pay your money on the 14th. Is that okay? At that time, I told them, okay, the I would disregard the eviction, and I will give you the opportunity to pay on the 14th. On the 14th, they did not pay. On the 13th, they told Brandon that a plumbing leak was happening at the house. So Brandon contacted me and said, hey, they say the plumbing is bad. Something is going on. I said, well, what's going on? Can you go over there and look at it? He went over there and looked at it, and he told me his version. At that time, I called White's Plumbing. White's Plumbing told me they will get over there. They didn't get over there on the 13th because they were on a gas call already. White's Plumbing went the very next day on the 14th. White's Plumbing called me back with the what was going on, and I approved him to fix it. He fixed it Saturday morning. I paid him Saturday morning. At this time, they still haven't called or still haven't paid their rent. I called her on the 14th because Brandon said for me to call her. I called her. She did not answer. I sent her a text message and said, hey, I was calling to talk to you about your rent, but you have not contacted me yet. She replied back to me that she would get off at 4:15. I said, okay, I'll call you then. I called her about 5 something. She did not answer the phone. So I called her again later on. She did not answer the phone. I called her the very next day. She didn't answer the phone. So I sent her a notice on the 15th telling her that due to non-communication, that you still have not paid your rent, I'm going to move forward with this eviction. So I sent her that. Then she sent back to me saying that Brandon hadn't done some stuff. Well, I didn't know what she was talking about because everything is done in the house that's supposed to be done, he was supposed to go back and put the quarter round board around the base of the floor. And I told her I was going to add some plugs in there because that is an old house and it has like one plug in each room. Brandon was supposed to go back over there and do that. But during the time of the eviction, she started cussing everybody that comes over there out. The maintenance man came to cut the grass, Pastor Cummings. She cussed him out, told him to get off the yard. He contacted me. I told him, do not go back over there. She's in the process of eviction, so she's being ugly, disrespectful to everyone. She contacted Brandon and told Brandon, don't bring your mother ass to my house again. You come over here and fix shit when I get out.
Mr. Great, Mr. Great. All
Yes.
right. You're in court, so let's refrain from the curse words. Let me
Okay.
ask you a couple just question. You say this eviction notice. So did you give them the notice via text message or did you actually hand them the notice?
I went over there to the house, knocked on the door because
Okay.
I've evicted people before and I went through you before and you told me exactly what to do.
All
I
right.
put it in her door, took a picture of it and sent it to her so she can see that I know I left it in the door and I have proof. Then I
Posted on.
also sent her a text message. Then I also came up there and filed the eviction up there and
Okay.
had her served.
So you posted it on the inside of the door and then you took a picture.
Yes, in the screen door and took a picture.
Now we're getting into the financial core of the dispute, and this is where eviction cases are often won or lost. The numbers here are actually very specific. A monthly rent of $1,175, a partial payment of $555, leaving a base balance of $620 for November, not even counting late fees. From a purely mathematical standpoint, the judge is establishing that rent was not fully paid. But what really stands out is the communication breakdown. The landlord repeatedly emphasizes, "I don't hound tenants, I expect them to call me." The tenants, meanwhile, communicate through the maintenance man instead. Legally, that's a risky move. Courts generally expect rent issues to be addressed directly with the landlord, not through third parties. Here's the uncomfortable truth. Even if you're struggling, even if repairs are pending, silence can hurt you in court. Judges don't reward assumptions, they look for documented effort. So ask yourself, if you were in this situation, would you have handled communication differently?
Main entry door.
Main entry door. And I can send that to you if you need me to.
All right. So you got a month-to-month agreement. You posted the notice on the inside of the main entry door.
Yes.
And the tenants are delinquent in back rent for the month of November. The
Yes.
555, they paid you 555, right?
Yes.
So in our
And
reality,
the lease agreement, the late payment is a $50 and $5 after every day until rent is paid.
okay. So just
Then
back rent alone, not including late fees and everything, is $620 that she owes
yes.
you for November. Okay. All right. So let's hold off there. All right. Okay. So let me go on to, did you brought Mr. Lacey in? Is there a reason why he's here?
Because she stated to me that Brandon Lacey did not do what he was supposed to do. And Brandon Lacey did everything he was supposed to do. And him coming back to put the baseboards has nothing to do with her paying her rent.
All
He
right.
did not come back over there because she started acting immature for him to go over there and it'd be a conflict of him going over there and
Okay.
her cussing everybody out. So I told him not to go back over there.
All right, so right now there's a need for Mr. Lacey to speak. So let me go on to the defendants. Ms. Henderson, you, Mr. McGinn, tell me why you feel like you should not have a judgment against you and you should not be evicted. Go ahead.
So we did acquire the key on October the 23rd. When we moved in, the house was not finished. Mr. Lacey was in the middle of, I guess you would say, renovating. Um, I wrote a timeline. On the 24th, I sent him a message and I asked him, when he was going to come back and finish doing the things. Long story short, Brandon did not come back for 10 days. Finally, when he came back, there was a rodent problem. There was, of course, the water issue. We had reached out to the city and we had them come and do a inspection. When they did the inspection, they gave a 12-page code violation, including there was no permits and things like that to be working on the home. I asked Brandon, because that's who she was communicating through. That's who she.
This is where the case shifts from numbers to living conditions, and emotionally, this is the tenant's strongest moment. Allegations of rodents, plumbing failures, exposed wiring, missing appliances, and a 12-page city code violation report are serious. If proven, they raise legitimate habitability concerns. But here's the legal tension: uninhabitable conditions don't automatically cancel rent obligations. Tenants usually must follow specific steps: formal notice, time to repair, sometimes rent escrow, before withholding payment or moving out without liability. The judge is quietly probing for that paper trail. What complicates things further is timing. The tenants say code enforcement was contacted after payment issues began. That sequencing matters. Courts often ask, was rent withheld because of conditions, or were conditions raised after eviction started? This is the heart of the case. And it raises a big question for viewers. If a place feels unsafe, what's the right legal move before stopping rent?
That's who she was supposed to send our receipt through. Finally, she sent the receipt maybe like 20 days later, and the receipt was wrong. However, Brandon is the person that we were communicating through because that's how she was communicating with us. I have several messages telling him that he did not come and do anything. He wasn't doing anything. The things that were supposed to be done when we moved in, those things are still needing to be done. Once code came over, well, actually, we told them that we were going to call code, and that's when she sent the eviction notice or sent the little text message saying that she was going to evict us. I actually wrote down a timeline for the past month with our chat history. What else? Absolutely nothing was done. The things that were told that were going to be done when we moved in on the 24th, absolutely none of those things were done. Like I said, I have pictures, and so does the city of Waco code enforcement. We did pay early, and it had absolutely nothing to do with not being able to pay our rent because we both have good jobs. It was under good faith that the stuff that she told us on the inside to make us comfortable were going to be finished. We were able to see up under the home. All of the plugs and light fixtures had wires showing. We literally had to go and help Brandon get it clean for us to be able to move our stuff back in. Brandon came over there maybe like 2 days out of the full 21, maybe 25 days that we stayed there. And when he was there.
1 second. Mr.
Yes,
Gray, Mr. Gray, Mr. Lacey, you're still in court.
I'm right here.
I'm sitting right here.
No, I need to see
I'm
you.
writing down what she's saying.
I need to see you, because I'm letting you know. Okay, so
Sorry about that. Sorry about that.
Until I excuse you, you need to be present in court, okay? And go ahead, Miss Henderson.
Yes, sir. So from October the 24th up until November the 6th, we had plumbing problems. They finally sent a plumber over there on the 9th. Excuse me, the 11th. And he told us everything that was wrong. The fire department came and turned the gas off because they said all of the 3 heaters that was there were illegal. Brandon actually took a heater from the house. He said that she had him come and get it. It was just a lot of stuff that was wrong, and she just refused to come and fix. Yes, at the end, I did not let anybody come. I had acquired an attorney at that point, and she stated since they was going through the eviction process, then for us to basically just do what we needed to do on our end as far as our answers and making a timeline, nothing was done. And the report, the code report is, I think, believe for the 19th or the 20th. All of those things that she said Brandon did or Brandon told her that he did is on that report, is not being done. They told us it wasn't even habitable.
Okay. When did you call? When did you call the City of Waco code? Code?
Let's see. I told him on. I told them on the 6th that I was gonna call code. They brought Brandon and some other guy over there to try to fix the plumbing, even though I feel like she knew that it was something with the plumbing because the day we signed the lease, she said, I have a plumber. If
When
anything is wrong, let me know. Go ahead.
when did you call code
I
enforcement?
finally called code on them on the 11th.
Okay, called code enforcement on the 11th.
Yes, sir.
They came out and found several violations
Mhm.
that wasn't in compliance with code. You said it was 12 pages long.
Mhm.
And I'm quite sure, seeing if you received it, Mr. Great should have also received it as well from code enforcement.
Yes, sir.
Okay, did you notify code of Mr. Great and that she was?
I haven't received anything from code. All this she's saying, this is my first time hearing anything about code. The only thing that I heard about is on November the 13th, Brandon said there was a plumbing issue. The people that were living in the house before were mentally challenged. So she stated that she smelled sewage when she flushed the commode. Brandon contacted me on the 13th and told me that the tenant said that there was a plumbing issue. At that time, I called White's Plumbing. The reason I told her that I have a plumber on hand because I have good people that come and fix something right away. I also told her that it would be done within 2 to 3 days if she called me and tell me something, unless they
Okay,
are out of sight.
Can
I
I
got
say something, please?
so here's the next question that I have to ask you. Miss Henderson,
Yes,
uh
sir.
did you did you file a maintenance request with Mr. Great, or did you just contact Mr. Lacey?
So the very next day that we moved in, I messaged Brandon because that was the maintenance man. She told me to contact him for maintenance, her for payment, like she just said. I called Brandon the very next day. I texted him. I actually have it in writing. And I told him that it was something wrong with the plumbing. Again, they didn't bring anybody over there to fix the plumbing until um November the 15th. No, it was November the 15th. And they did not tell me that anybody was coming. They came like it may be 7 in the morning and turned the water off, in which that was okay because I needed it fixed, but it's also a problem because I work from home. After they actually was saying that the people from White's Plumbing, they didn't want to use them. It was a lot of stuff, and we were just caught in the middle. She was saying that she paid them previously $10,000. They didn't do what they needed to do, and that didn't have anything to do with us. But after I called code and they fixed the plumbing, and then that's when she illegally had the water turned off.
Okay, let me just ask you this, Miss Henderson.
Yes,
Stated
sir.
that you stated that, y'all agreed that you contact Miss Mr. Lacey for the plumbing and you contact her for the rent. She's evicting you for non-payment of rent. Is there a reason why you didn't pay your rent like you were required?
So she spoke with Jonathan, and yes, sir, because the house was inhabitable. I asked them on October the 27th, which is 5 days after I moved in, if she could just let us have our money back and we could go and find us somewhere else to stay because Brandon wasn't coming and fixing anything like they told us they was gonna do, and it was full of rats. Everything that she put on the lease was a lie. We didn't have a stove, so we couldn't cook. We didn't have a refrigerator, so we couldn't hold food there. Literally everything that was on the lease was literally a lie. Literally.
Okay, so are you still staying there at this terrible place?
No, sir. No. After we contacted Code and Code came and said it was inhabitable, we moved.
Okay, did you notify Mr. Lacey or Mr. Great that you moved
Yes,
out?
yes, sir. Mr. Lacey actually has been my best friend for the past 10 years. So he playing both sides, but he was fully aware of everything that was going on.
When did y'all move out?
We moved out on the 27th.
The 27th of November?
Yes, sir.
Did you give the keys to anybody?
No, we left the key in the mailbox and we moved out because we were it was a self-help eviction. The water and the gas was part of our lease. She went and had the water turned off. So we couldn't live like that. And I worked from home. So it was like we had to move. She didn't give us a chance to come to court and see what the outcome was.
So did you contact Mr. Lacey or Mr. Gray and say, hey, I'm out? You know, here's the keys.
We let Brandon know that we had moved out. Brandon actually had to come and get his material that he was storing in the house. And I told him, like, hey,
Okay.
we pay for every square inch and you've been storing material for almost a month and you haven't came and fixed anything. Can you come and get this stuff or I'm gonna have to start charging you for storage?
All right, so let's stop there. Mr. Lacey.
Yes, sir.
Yes, sir.
Mr. Lacey. All right. Now we're up to you, Mr. Lacey. All right. Did Mr. Gray, did Miss Henderson contact you on or around the 27th of November to let you know that she's moved out and you can come get your stuff or whatever?
No, she told me she was moving, but she didn't tell me to come get my stuff.
Have you
You
been
say-
by this have you been by this house lately?
No, sir. No, sir.
You haven't been by there.
No, sir.
Okay.
Your Honor, he came and brought me some of my tools that he took with him. So he's telling the story.
But that was a few weeks ago.
No, that was about a week ago, Brandon. That was like a day before Thanksgiving.
I didn't
Okay.
come off the day before Thanksgiving.
All right. So hold on. You said the day before
Well,
Thanksgiving.
look, I'm gonna tell you, Judge, I came with her the same time the plumbers was there.
So Thanksgiving's on the 27th. Y'all moved out on Thanksgiving Day?
We moved out the day after.
On the 28th.
Yes, sir, the day after.
All right. And you saying that you contacted Mr. Lacey to let him know that we're out and the keys are in the mailbox.
Yes, sir. Brandon had one of my daddy's tools, which was a caulking gun, and I asked him to bring it back, and he brought it back. And at that time, he asked me if he could borrow $25. Brandon.
This section is pure courtroom tension because now we're dealing with conflicting stories under oath. The tenants say they moved out, left the keys, and stopped communicating on legal advice. The landlord says she was never told. The maintenance man admits partial knowledge but not full confirmation. From the judge's perspective, this is a credibility puzzle. Courts don't like gray areas, especially when possession of property is involved. That's why the judge keeps circling back to one simple question: who is officially notified and how? Notice how the judge doesn't accuse anyone of lying, but also doesn't fully accept anyone's version yet. Instead, he slows the case down. That's not weakness, that's judicial strategy. Because when facts are muddy, judges look for verification, not volume. And right now, verification is missing.
Brandon, don't lie.
All right. Okay. So here's the thing. You're swearing an oath that you've moved out.
Mm-hmm.
The utilities in your name, you moved out and the keys are in the mailbox, is what you're
Mhm.
saying. But
Yes, sir.
you didn't tell Mr. Great. You just told Mr. Lacey.
Well, she started, we started having a back and forth. She sent me some messages telling me to shut the F up and being really nasty. And so we both stopped communicating with each other. I got a lawyer and my lawyer told me not to communicate with her anymore, that I just needed to communicate with the court.
All right. Okay. So let's stop there. All right, Mr. Great. Is this any of this new to you for as her giving up the rights to the property as of the 28th of November?
No, she did not tell me she moved out. The reason why she texted me and said, I'm gonna move out, file the eviction. I stopped communicating with her. And I did curse her. Yes, I did, because one night she texted me all the way at night from at 9 o'clock at night to 6 o'clock in the morning and just kept texting and cussing. I'm on one tonight. I'm up all night. And I kept telling her, please stop texting me. You got everything that you need from me. All the paperwork for eviction. And she continued on. And it teed me off because she's acting immature. So I said, stop texting my MF phone. But besides all that, she never told me that she was moving out. She told me to file an eviction. Brandon never told me that she moved out or that she was moving out. Again, I told him to stop communicating with her. I didn't even know that they knew each other until she started texting me, and that's how I found out that they were more than just friends. And so I said, oh, okay, so now I get it. So
What's more than
everything that
just
she
friends?
said is a lie. She's
Yeah,
lying.
you just friends.
Let me do this. Let me do this. Let me do this. So, Mr. Lacey, are
Yes,
you stay in this area?
well, I stay in South. I stay in South Waco.
Okay, you stay in South Waco. You're on the south side. Okay. All right.
Yeah,
So
yeah.
here's the thing. Here's the thing. This is what we're gonna do. This is what we're gonna do. I'm gonna reset this case because Mr. Great trusts you to take care of the property, right?
Yes, sir.
Okay, this is what we're gonna do. I'm gonna reset this case for 24 hours. Mr. Lacey, I want you to go to
This is a fascinating judicial move. Instead of forcing an immediate ruling, the judge resets the case for 24 hours and assigns a real-world task: confirm whether the property is vacant and retrieve the keys. This is problem-solving from the bench. Legally, this sidesteps a messy eviction judgment and focuses on resolution. If the tenants are truly gone and the landlord regains possession, the case effectively dissolves. If not, then consequences follow. This moment highlights something important. Judges aren't just referees. They're often mediators trying to prevent unnecessary damage when emotions are running high. And honestly, this might be the cleanest outcome for everyone if the facts line up.
I want you to go to the property, confirm that she's moved out, get the keys, get those keys to Mr. Great. All right,
Yes, sir.
that's what we're gonna do. All right, because right now it's a big miscommunication. All right, and my goal right now is to make sure that there's some type of resolution in
Yes.
in this particular suit. That's gonna be the key. I need to resolve. That's my goal, is to not to mediate, but to resolve the issues that are at hand. All right. And so that's what we're gonna do. We're gonna try to do this peaceful as peaceful as possible we can. Now you, Miss Henderson, you stated that you moved that, you're not there. So when Mr. Lacey go by there today, it's gonna see an empty house. And the key's gonna be in the mailbox, right?
Yep.
All right. Okay. Now, Mr. Great, this is what I want you to do. Once you get the keys in your hand, I just need you to send an email to the court. Says, hey Judge, I got my keys. I'll wash my hands with it. I'm through. All right. Because that's pretty much how we're gonna end up doing. All right. Okay. All right. So here's the thing. Now I'm gonna reset this for 24 hours. Now, if everything that has been said to me is true, we'll close out the case. But if it's not true, somebody's gonna be unhappy. All right.
And Judge,
Yes, ma'am.
I drive trucks, so when Mr. Lacey contact me and say he has the keys, I'll send the email through the courts. But if you try contacting me tomorrow, I will be driving and I have cameras in my truck. I cannot answer the phone. It will have to be when I pull over.
Well, that was always the excuse when we tried to reach out to her too, and I
I'm
have that in
talking right
writing
now,
too.
Antoinette.
Listen. Y'all really about to. All right, listen. All right. Come
Judge,
on.
all I want is my keys and her at the house because
Okay.
We've been at the house, but I
I
asked for
have
my
plenty messages. I have plenty messages where I
See, this what happens. And this is the reason why I like Zoom. This is why I like Zoom. All right. This is exactly why I like Zoom. I ain't got I can sit back and I can just let y'all talk and can't hear a word. Okay. I want to say that I love y'all. I do. Okay. All right. So like I said, I'm just gonna I hear you, Mr. Mystic. I understand you're a truck driver. I get that, okay. All right. So let me ask you this, Mr. Great. What day, what's gonna be a good day um for us for what's a good time tomorrow? Let me just ask you that if there is a good time. And I'm gonna unmute your microphone, Mr. Great. I just need to know a good time, okay? That's all. All right, Mr. Great. I'm gonna unmute your microphone. Go ahead. You can talk now. Unmute your microphone, Mr. Great.
Is 4 o'clock a good time?
I
Is that too
I
late?
I can go 3:30.
Okay, I'll pull over, call you at 3:30.
Okay, that's in the event. In the event that you don't get the keys. Okay.
Okay, and if I get the keys, all I gotta do is email the courts. What's the email?
All right. JP2
Wait a minute, JP2
at mclennan.gov.
at mclennan.gov.
.gov.
Okay,
All right.
I'll email you.
Okay. Mr. Lacey, you got your marching orders, right?
Yeah. Yeah, I got that, Mo. Yeah, I got it.
Okay.
Yeah, I got it.
Okay, so we're just gonna, reset it for 3:30 tomorrow, and just, once I get the email, I'm gonna, once I get the email, let me, Miss Henderson, what's your email address, Miss Henderson?
ZEE Kelly 87@gmail.com.
Make sure that's ZEE Kelly KELLY 87@gmail.com.
Yes, sir.
Okay, so what the court clerk is gonna do is she's gonna just reschedule it tomorrow for 3:30. But once we get the keys, once Mr. Gray gets the keys, she's gonna send me an email, and once I get the email, we're gonna take it off the docket. So you'll know right then whether or not you need to come back, okay?
Okay.
All right. All right, with that being said, I know our hearts and minds are not clear, but we're gonna go ahead and close this out until, I'm just gonna say until, okay?
In the end, this case wasn't decided by shouting, screenshots, or sympathy. It came down to timelines, communication, and verification. The judge didn't rule on habitability, didn't issue an eviction judgment, and didn't award damages. Instead, he pressed pause and demanded clarity. The takeaway here is powerful. In landlord-tenant disputes, documentation beats emotion every time. Rent payments, repair requests, move-out notices. If it's not clearly communicated and provable, it may not protect you in court. Whether you side with the landlord or the tenants, this case shows how fast things can spiral when communication breaks down, and how the law prioritizes process over perception. If you found this case as shocking and revealing as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns just like this one.